I can, loud and clear, my friend.
Awesome, awesome. Well, I appreciate you letting me come on here and ask this question. Uh, but with the new case law that happened, this is pretty specific to the West Coast, maybe just California.
Yep.
People versus Leal, I think it's Leal.
Mm-hmm.
Uh, Basically, in certain circumstances, we've lost probable cause to the trunk of a vehicle unless we have specific probable cause. I'm wondering under what circumstances I have to adhere to that. Like that case is kind of specific because they watched him get close to the trunk but didn't see him go in it.
Yeah.
If I've got just your average, I found dope in the center console or it's open, I can see it from the window. Do I still have the trunk or when do I lose the trunk now, I guess, in a probable vehicle
First of
search?
all, right. So first of all, you are a cop in California, and I think, is it fair to say that, Sean, we know each other, right? Have you been to one of my classes or no?
I have, yeah,
Yeah.
department back then, but I've met you once in person, then I've gone to a bunch of your online stuff before.
Okay, okay, because I know I've taught at your agency. Well, yeah, I taught your agency right now. I don't say agencies on here just because I don't know if people want that on there. But anyway, so that's besides the point. So I'm glad you're here. So, Zach, do you want me to give a background on Leo? Or do you want to?
Yeah, you can, either way.
So briefly, what happened is this. Okay, so an officer is watching Leo, who is, I think, a juvenile, but he's at least on juvenile probation. So I guess he's not on adult probation, but he's on juvenile probation, and they see him with a firearm, and they see him. The undercover cop sees him put the gun underneath the front seat. He gets in, allegedly under the front seat, and then he gets into that car, and then they drive away. So he's a passenger. Leo is a passenger. And Sean, if I'm wrong about any of these facts, you let me know. Then, of course, marked units pull him over. They search the car for that firearm. He's on probation, right? And so they look for the gun. They do not find it. They then pop the trunk, and what do they find? They find the firearm. The Court of Appeals. Now, this is not a California Supreme Court decision, so it does not have, a massive amount of persuasive or binding authority, but it's definitely it's persuasive to a lot of states because a lot of places, because California is a Fourth Amendment state. They interpret the search and seizure under the Fourth Amendment, not their own constitution. So when the cop was asked in court, hey, did you have any reason to believe, the one that was watching Leo, that the gun was put in the trunk? Was there a pass through? Did you see him go into the trunk? Did you see anybody else go into the trunk? The answer was no. The only thing that they knew was that they thought that the gun was put under the seat, maybe because of furtive movements, and he was under constant observation. The court said that was an unlawful search of the trunk, and that's where Zach is going to come in and explain maybe what is going on here, because a lot of cops, right, Zach, they think that if I have PC for the car, I get the whole car. And that's, I think, what Leo is saying is back up. That's not really what the law is.
Yeah. So the automobile exception potentially gets you the entire vehicle, but it's going to be driven by what you're looking for. And so if what they were looking for was this particular firearm, and they didn't have any reason, as you mentioned, on these facts to believe it was in the trunk. So, to carry that out to searching in a car for a user amount of drugs, unfortunately, the case law is not consistent. I'm pretty sure there's a New Jersey case that says if it's just a user amount that you find in the passenger compartment, you need additional facts to believe there could be more drugs in the trunk. Other states don't take that position. So, but what you're looking for is going to drive where you can look, and it's not automatically I get the entire bumper to bumper search of that car. So I think Lee's correct.
I think it is. I think it is in a sense that, first of all, look, what's that? Wyoming versus Houghton that's how I say it. Do you say Houghton?
I say Houghton.
Houghton. Okay, Houghton's probably more correct. So in Wyoming versus Houghton, the Supreme Court upheld the search of a passenger's purse that was near the driver when they had probable cause the driver had drugs in the car. And the reason I bring up Houghton is because a lot of cops think Houghton stands for the proposition that I own the car if I have PC. Have you heard that before, Zach? I mean, cops talk
Yeah.
like this. They're like,
Yeah.
if I got PC for the car, I own that car. We need, look, I'm getting all agitated here. We need to stop talking like that, okay? Courts are done with this whole generic articulation business. They don't want to hear you own the car. That shit's mine. If I have evidence for, if I have probable cause for the car, I get the air box in the engine compartment. They want to know why. And maybe it's unfair, but they just want to know why. And Leal is an example of this. They just want to know the why. And when we go to court and say it's possible the gun could be in the trunk, well, possibility is not probability. You cannot search anything with a possibility. You can only search things with a probability. And this goes back to Ross. Okay. So you search the car as if you had a warrant. So let me read to you what Leal said. Okay. So Leal's 2023, California Appeals Court. It said a survey of cases applying the automobile exception reveals courts generally find warrantless searches of trunks and other enclosed compartments in a vehicle justified in 3 categories of circumstances. We didn't go into this detail, but it's pretty high level. It says 1, officers have probable cause to believe contraband or evidence of the crime will be found specifically in the trunk or other enclosed compartment. So what they're saying is, if your probable cause is specific, meaning your CI or your observation said, hey man, they put that gun in the air box, then that's probably where you get, right? Number 2, a search of the passenger compartment reveals contraband or other evidence generating further probable cause to search the trunk or other enclosed compartments. What they're saying here is, for example, you have you search a car and you find a fraud lab, the skimming devices and other things, and you also see like receipts to based on this fraud, right? This fraudulent activity, you see receipts for a bunch of brand new items that were there from today. Like you saw that the guy bought a MacBook Pro from the Apple store with one of these fraudulent credit cards. Would that give you a reason to believe, right, that the evidence that MacBook Pro could be in the trunk? The answer is yes. So open the trunk. Or number 3, probable cause exists as to the entire car. Example, if the contraband or evidence of the crime will be found somewhere in the car, just somewhere in the car. The search of the trunk here, they said in Leal, the search of the trunk does not fall in any of these exceptions. So that last one is like, you have probable cause that this is a trafficking car. This car is involved in trafficking. It just came into Virginia, from Maryland. It's loaded down. That's your probable cause. Where do you get to search? You get to search the whole thing to find the trafficking evidence. And Shane is saying articulation. So that's really, I think, Sean, is going on in Leal. It is, I don't want to say it's a game changer, but I want to say that I've been kind of asking cops to be prepared to articulate a nexus for this stuff many, many years ago. And I'm not saying I was premonition. I'm just saying that I don't like cops saying, hey, we own the car. Those days are over. Courts don't like that stuff. That's where we're at. What do you think, Sean?
I appreciate it. I think there's a couple other California cases that basically prove that. I don't know, Brazil or something. They came out last year talking about when officers say stupid things on camera and they can clearly tell they're trying to get into the car and search for places that don't really have probable cause. So that makes sense to me. I guess it's going to be more of a show. For a lot of cases, I think a lot of officers that want to get into cars the way that they used to, they'll just have to get better at articulating it.
Yeah, you look, I mean, that is no doubt. There's undoubtedly what you said is absolutely true. However, in 99% of these cases, it's business as usual, but you just have to be able to articulate. I mean, this guy was under surveillance there was no lapse in surveillance. If there was a lapse in surveillance, then I think we win here, because then it's likely that he could put the gun in. Look, first of all, I got to tell you, when I read the case, Sean, like over a year ago, whatever it was, that was the first thing I thought. I said, if this vehicle is really being surveilled with no brake, that, as the court said, how the hell did he get that gun in the trunk? Because that was his gun, right?
Yeah.
So there you go. I mean, what I thought to myself is that these cops are just like talking in generalities. I didn't break any constant contact. Well, clearly you freaking did. Somehow that gun made its way into the trunk. So clearly you did not surveil that car 100%. So don't talk like that. say the truth is probably that he probably looked over to the left at a pretty girl or something. And that's when the gun went into the trunk. In other words, we need to hear that. Does that make sense?
Yeah, I think there's a lot of case law. It's just we've gotten because cops make bad reports and write it incorrectly. But
Well, you got me there, my friend. I mean, there's no doubt about it. So, all right. Good job.
Well, I appreciate it. Thank you very much.
Yeah, now beat it. Okay, so
Can we get Jeff Ship from Montana on?
we sure can get on the love line with Zach and Tony.
Jeff, can you grab your mic?
All right, let's see. Old Jeff here. Okay. You should see pop
Okay.
up. Hey, what's up, Jeff?
Hey, you can hear me?
Good. And actually, 1 second. Hey, Roderick, can you get on deck so we can grab, Wiggins? So I want to answer your question as well, okay? But hopefully we want to turn on your mic because we need to talk to people, not just read stuff. All right. Okay, try to get it working, Roderick, in the meantime. All right, Jeff, what do you got, my friend?
So I'm up here in Montana. We need particularized suspicion in order to run our dog for a drug. And so basically what I was trying to do, that I live in a party town right next to Yellowstone Park. We don't have jails. When we have a DUI, we seize the vehicle. We impound it. That's our policy.
You give them a ticket or what?
Yeah, we scratch them out a ticket, send them on their way, seize
Yep.
the vehicle so they don't get back in and drive it.
Yep.
What I'd like to do is run my dog on the vehicle after we've seized it, because we've already done a major encroachment in the Fourth Amendment by seizing it. So I don't think running the dog is a huge hindrance. I don't have particularized suspicion of drug activity, but I don't want the tow truck drivers to be exposed to any fentanyl, needles, paraphernalia, or anything that's in the car.
Right.
So what do you think about that?
You're the last true humanitarian, my friend. You care more about those tow truck drivers. They probably want to be exposed, just so you know, Jeff. You're probably hurting them more than anybody. What do you think, Zach?
Yeah, so Montana is kind of the search and seizure case law in Montana is very difficult to coalesce together, to synthesize. There is a lot of policy-driven decisions, in my opinion, by the Supreme Court in Montana, and they're not consistent with each other. They're very outcome determinative, in my opinion. So we have the Sheets case. Sheets was the State versus Sheets, which was the luggage at the airport, where the Montana Supreme Court said it wasn't a search to run the dog around the luggage because the person, it was checked baggage. So he checked the baggage. He didn't maintain control of the luggage. He subjected it to government and private handling of the baggage. So to run the dog there wasn't a search. So you don't need the particularized suspicion there. But then there's the Ellison case that talks about, you do have a reasonable expectation of privacy inside your car in areas that aren't subjected to plain view. The case you're referring to, I'm sure, is the Tackett case. That's where the court said it is a search for a dog to run your dog around a car when the person has maintained control of the car. So I think that's going to be the key here. And then you need particularized suspicion. That's correct. So to run my dog around a car where the person still has control of the car, like on a traffic stop, that does require particularized suspicion. But here, and I couldn't find a case on point, so this is my opinion. I think if you take the Sheets case and the Tackett case, the person is no longer in control of the vehicle. They've found themselves under arrest for drunk driving. It is not unreasonable to think your car is going to be impounded in that situation. I don't think that's Tackett. I don't think you need particularized suspicion to walk the dog around the car in that case, since you are taking control of the vehicle. No, that's my opinion.
I agree.
Case
I
on point.
agree. I think that's the right answer, based on what I know about Montana case law as well. Montana sounds like a place that would probably be the same as Alabama and Idaho, case law. but they
It's
got
not.
something up there. I don't know what the hell their problem is, man, but they love to be more like Washington than Idaho.
And they rely on the specific right to privacy protection that's embedded in their constitution to make these decisions.
Well, that's all, yeah, that's all just
Yeah.
what they want.
Yeah, it's policy. I think it's policy driven in a lot of these
Oh, yeah, it's
cases.
policy driven. Just like Washington and Arizona. Did you know this? Well, you know this. You've been traveling all around the country. Washington and Arizona have the exact same search and seizure provision in their constitution. Exact same. It's written exactly the same. And
Mhm.
Washington and Arizona could not be further from center.
Right.
Each way, each way, right? Okay. So there's your answer, Jeff. We're not giving you legal advice, but we think that based on understanding of Montana case law, that can be done under those circumstances, and that's what we have for you.
Appreciate it. Thank you for your
Welcome, my friend.
opinions.
Same here. So Jeff, is Montana one of that does not have an appeals court? That would not surprise me. There's a few states that are.
No,
Yeah, it only has a Supreme Court.
Who does?
It's only Supreme Court straight from Justice Supreme.
Yeah,
No
it
appeals
doesn't
court.
have an appellate court.
Mm-mm.
Right.
No.
Is that where the Dunsons live, or is that Wyoming? That's Montana.
Montana.
Oh God. Yeah.
Oh, what? Oh, what? Oh, so look, let's hear this BS. Okay, I'm gonna call you out, Jeff. I'm from Nevada. We have Reno 911. You have the Duttons. Okay, you want to switch?
Gladly.
Yeah, my ass, man. I'll take the Duttons any day. At least some class, man. We got booty shorts. That's what they say our cops look like. Your rangers over there are killing people twice a week.
I wish.
Yeah, DNR cops are fucking having more shootouts than LAPD. All right. All right, Jeff. Nice. Thank you. Hey, I want to get Jason on here. Jason has a good question. I have the answer, but Jason, can you come on, please? Just on your microphone. Jason Murphy. Let me try to turn your mic on. Just give me a thumbs up. Or say yes or no to this. It's coming on your computer. Hey, what's up, Jason? Are you in California? No, I thought it came on. Nope. All right. You see what Jason wrote, by the way, Zach?
Yes, the probation conditions.
Mm-hmm. It's a very, very good question, and I actually was thinking about that. I have the answer. I think the outcome is the same.
Yeah, can't you search his vehicle in that case if he's got a?
Well, it's not his vehicle. That's the problem.
Oh, that's right. It was the Layall is not the juvenile. Yeah, Layall is the owner of the vehicle.
Right. No.
Yeah.
No. Leo, whatever his name is.
Leo, whatever his name is. No,
Is the passenger. He's not the owner of the vehicle. If he was the owner, then we could search it.
Yeah, the juvenile with the gun, I don't think is the owner of the vehicle.
Correct.
Right.
All right. So the problem is that Jason, it's a great question. It's a fantastic question, but the problem is that Leo has no common authority over the vehicle. Therefore, it's not only the area where he has common authority over is searchable under his conditions. And but these facts, he has no common authority over the question, over all right, Rod. What's up, Rod? Let's see what Rod has to say. Rod, can you let's hear this live. What's up, Rod?
Are you there?
Yo, what's up? You're echoing a little bit. Where are you at? Where are you from, by the way?
I'm from Iowa.
Oh, Iowa. Oh, so you make bad case law along with Sean, huh?
That's what we're here for.
Where I love Iowa. Where in Iowa are you?
Cedar Falls.
Oh man, what a beautiful place. All right, cool. So Rod, what you got, my friend? Sean is go ahead. Sean is in what? Where's Sean? Sean is in Scott County.
Okay, that's southeast Iowa, yeah.
Yep.
So you're walking down the street on the sidewalk. A couple guys walk by you, got a fresh odor of burnt marijuana coming from them. Are you searching them? Do you have the exigency exception to search them under the form? The same as a mobile vehicle? Does that apply to people as well?
Okay. So first of all, let me ask you in Iowa. What are you citing this person? They're not getting arrested. That's safe to say, right? They're not getting arrested because they smell like burnt marijuana, right?
If they have marijuana on them, yes, it's controlled substance, it's arrestable.
Okay, fine. But do you, based on your facts though, do you have probable cause to put them in hooks right now and say you're going to jail? Yes or no?
No,
Well, isn't that the problem? In other words, where is your, and maybe Zach has a different view of this. This is how I view this. When you search them, you're gonna search them under a few conditions. Either one, it's search instant to arrest, which you don't have here. We agree.
no,
Well, the other search is that you have probable cause that they currently have evidence on their person.
correct.
And that is a very narrow, tailored search just to recover the evidence so that you don't leave with the evidence and you can cite them and release them. But I think that's my problem. My problem personally is that, you're not going to arrest them. That's kind of clear because you don't feel like they have, in other words, you don't feel confident enough to arrest them. And you're not saying, hey, you have drugs on you. I know you have drugs on you because, right? What you want to do is, it seems like what cops want to do is kind of like just look for the evidence and we go from there. Isn't that kind of where we're at here? You want to look for the evidence because if you find the evidence, are you going to take them to jail potentially?
Yes,
Well, so that's the problem. The problem is that I don't think that the level of confidence doesn't seem to be there, because it seems to me that you're just you're doing like more exploratory search. You're just trying to see if they have this evidence and we go from there. I don't think that based on them smelling like burnt marijuana alone, you are articulating that they have this evidence. That's a fair probability that they have this evidence, but that's kind of how I look at it. I'm uncomfortable just officers just doing as a matter of routine just because somebody smells like marijuana. And before Zach gives his 2 cents here, which can be maybe the opposite of mine, I will also say that, a lot of cops, when they smell marijuana and so forth, they really just have nothing more than the fact that they smell like marijuana. But that's my viewpoint generally on this, Zach. What is yours?
I think if it's clearly distinguishable as a fresh odor versus just this stale odor
Yes.
of marijuana, this
correct,
is
fresh,
Wait, you said, I thought you said burnt.
fresh burnt odor, yes.
fresh
it's
odor
Oh,
of
there's a
burnt
difference.
marijuana.
Fresh
Yeah.
odor of burnt marijuana, yes.
The fresh odor of burnt marijuana.
Well,
As-
it's not, it's not cut marijuana where it's not been smoked yet.
But it's also not that lingering stuff that's on your clothes
Yeah, I
because
call
you
it
hang out
ninch.
with people that smoke all the time.
Yeah,
Yeah.
the lingering, you know?
Yeah.
So you're gonna go, so just make sure we're on the
Yeah.
same page, because I'm telling you,
Yeah.
like, these courts are they're pushing back on these marijuana searches. They're just pushing back, because a lot of cops seem to just have done them in the past with nothing more than the smell of marijuana. But are you going to go into court, Rod, and you're gonna say, I have probable cause based on these factors? I would like more than one factor, just the fact that he smells like burnt marijuana. Do you have something more than just like, do you have probable cause that he currently has paraphernalia or marijuana on his person?
All you have is the odor,
That's it.
that's it.
I wouldn't do it, but look, I wouldn't do it because I don't think the courts want to hear one reason for probable cause. Now, what about the fact that he may be under the influence? Does he appear, we can detain him. You would agree there, right, Rod?
Yes.
So does he appear to be under the influence?
When you say under the influence, are you talking about illicit drug or alcohol?
No, marijuana.
Marijuana.
Okay.
Glazed eyes.
Well, yeah, I mean, if his pupils are dilated, and maybe his speech is off a little bit.
That's what I'm talking about. That's what I want my students. I don't want my students. There was an instructor out there who said, if you smell like marijuana, you can search the people. Just stop them and search them. And I've always took, what's the word, right? I just did not like it. I was like, it was insulting to the Fourth Amendment in many ways. So I want something, personally, my students, I want something more. And there usually is something more. They're lying to you. Oh, I didn't smoke marijuana, but yet they smell like burnt marijuana, right?
Right.
They look under the influence. Maybe you know them, they have a prior history. When they see you, they do a 180 and start walking away. I'm just saying in 2024, there's usually something more than just a smell of marijuana. But I feel confidently that if you go to an Iowa court and all these other courts that are kind of like pushing back, and you say, Your Honor, the only thing I have is that he smelled like marijuana, burnt marijuana, I think you're going to have a bad day in court.
Works for me.
Yep, have something more. And I think you have it. All right. Yeah, and I'm with Sean too. Have something more than just marijuana. Now, fresh marijuana might be different. Thanks, Shane. What's with this one? So look, here's the rules. We're gonna have to be, because we're getting so many people on these webinars now. I hate to do this, but we're gonna have to be more strict. And then we're gonna be strict about this. If you want to come on and do the mic, we'll answer your question. If not, we're gonna answer the questions that our viewers have already submitted to us on email. Because if we just do them, if we just answer your questions, then our people that have actually, so please, if you say microphone, I will answer, Zach and I will answer your question right now. If not, there we go. We got a customer on the love line. Nathaniel. I think Rick, you would agree with that, right, Rick? If they're willing to come on the mic, then they get their answer. If not, we're gonna go to the emails. What's up, Nathaniel?
Yeah, can you guys hear me?
Loud and clear, my friend. By the way, what state are you from?
California.
Nice. Okay.
Cool. So about a year ago, I stopped a vehicle. The passenger was on probation. The driver was not. They were boyfriend and girlfriend. So I had them step out, set them both down on the curb. They weren't in handcuffs or anything. Had my partner stand by them. Started my search, and I always start my search where the probationer is sitting. So started my search there. As soon as I opened the car door, I saw a purse that belonged to the female, and it was kind of a weird car setup. It's one of those where the driver and the passenger, in between, they don't have a center console, so it goes all the way to the floor. But there was a purse in the middle of it, and it was ajar just a little bit. But I thought I was good to search it since it was within arm's reach of the probationer. Searched it, and then I found an illegal firearm in there. It was, the DA refused to prosecute, saying that the search wasn't good. But I thought that fell under Gant or something within arm's reach.
Right. It's not Gant. It's not PC. It's not search intent to arrest. What county are you in, by the way?
Fresno.
So what do you think, Zach?
Well, yes, he's not under arrest, so it's not Gant. The probation searches are just the areas that the person has apparent authority over, right? Or has common authority over. This is her purse, and it's the guy that's on probation. So I don't think we can't search someone else's property unless we have some reason to believe he has authority over that purse as well. So I think the DA was probably made the right call here.
That's what it is. I mean, obviously that's what it is, right? Zach knows what he's talking about, but common authority is what you're looking for here. Common authority is generally joint access, joint control, or joint ownership, right? Either or multiple of those. Why would the cop believe that the boyfriend has access to her purse? And the thing is, we can't, I've dated many women, before many. I mean, I had 3 girlfriends my whole life, so I definitely know what I'm talking about here. And the thing is, I don't generally think I had access to their purse, right? And so I think that's what the issue here is. Where is the articulation, which actually goes back to what we were talking about with our friend before? Why do you believe they have joint access? Now, what I think a lot of cops may be kind of conflating is the Houghton case, where the cop searched the passenger's purse with probable cause.
Okay.
But that's probable cause, and then maybe Gant would also handle that as well. But here is a probation search. So she, strictly speaking, is obviously not giving up her rights. However, she does take a risk that when she hangs out and dates or befriends a person on California parole probation, that her stuff may be searched if the cop can articulate common authority. And here we don't have that. And so it is the right call.
Okay.
Nice job. Man, I really appreciate you coming on.
Yeah, I appreciate it. Thank you.
Yeah. All right. So we have Matthew Rader. No, actually Jack Riggs first. Right. That wasn't, yeah. All right. All right, Jack, what you got? And also, what state are you from?
I'm out in Colorado.
Okay, cool.
Have a question in
Wait,
regards.
can I ask you where in Colorado? I was just in Colorado. I was in I did a class in Firestone last week and also in Castle Rock. Not that you came.
I'm in Brush, Colorado. So
Okay, never heard of it.
Middle of nowhere. That's fair.
What you got?
So when given consent to access digital media, i.e. flash drives, things like that from a person in investigating a crime or an offense, but also being made aware of other crimes said person is involved in, if the party wants you to allow, or excuse me, wants to allow you access to particular information on there with their consent, does that follow the same suit as it would with a warrant? You're restricted to that scope, or can you then as well get a warrant to supplement the other information and media there?
Zach, you got the answer to this?
Consent, regardless of what the area being searched is, consent is always limited by what it is a reasonable person would believe they're consenting to. So whatever the language we use when seeking consent is very important. Obviously we would want it to be as broad as possible. But whatever the person is saying that they're consenting to is going to limit the scope. So if it's their flash drive or it's their property, they can consent to search any of it as long as the terms in which they state their consent would make it reasonable for you to believe that's where they're giving you permission to search.
Right. I guess my question to better clarify is, to give an example, they say, okay, I've got evidence of all kinds of crimes on here. I only want you to look at these.
Okay.
Would you be able to then go, okay, I know that these other issues tie into other cases. Would you be able to then go for a warrant on that?
Yes. I think so. So you have two things here. So I would search those areas they gave you consent to search first and find evidence of that criminality. And then you take that evidence that's corroborating their confession that there's other evidence of criminality in areas they don't want you to search. So you've slightly corroborated their confession. That's more than probable cause, I believe, to get a warrant to search those other areas.
Okay. Thank you.
Awesome. All right, Jack, thank you. Matthew. Let's see here. See you, Danny. All right. And we're winding down here too, by the way. This might be one of our last questions. What's up, Matthew? Where are you from, by the way?
Hey, I'm from Alabama. How are you guys this evening?
Good. Were you in my class today or no? You were in my class today.
I was attending earlier, yeah.
What, today? You're a chief?
Yeah. Pardon?
You're a chief.
No, the webinar?
Oh, no. I'm sorry. I'm in Alabama right now. I
Oh, really?
Well, I taught at 425 chiefs at the Chiefs conference in Montgomery.
Oh, wow. Wow.
So that's why
You're
I
right
just,
down the road from me.
That's right. I just was curious to see if you were in that class. But anyway, go ahead.
So my question is, we had a stop the other night. Rookie officer doesn't have that much experience. Stopped a vehicle based off the registered owner having a warrant. It was single occupant vehicle, goes up there, figures out that the driver of the vehicle was not the registered owner, releases the vehicle from the stop. Later on, we find out that the vehicle was suspected and involved in a crime in another city and had a switch tag.
Mm-hmm.
So just kind of Monday morning quarterbacking it. If he had made the stop based off of the warrant with the registered owner, gone up there, realized, okay, it's not the registered owner, but then discovered that the tag was switched while he was still on scene, will we be able to detain the driver and the vehicle for further investigation to see if it's stolen, et cetera, based off of U.S. versus Day?
I'm not familiar with U.S. versus Day, by the way. Are you, Zach? Is that a case that you're familiar with?
No, but if we've developed while we're investigating our initial suspicion, which turned out to be unfounded, but in that process we develop evidence of a new criminal act or new violation of the law, then yeah, we can continue that same detention. Mm-hmm.
Yeah, Matthew, why would you be hesitant on that? It sounds like some pretty straightforward stuff, right? If you're lawfully stopped a vehicle, which sounds like we're good, we had reasonable suspicion. And then we develop reasonable suspicion that there's other criminal activity afoot, right?
Mm-hmm.
So are you hesitating for anything else? Is there a policy issue or just something in Alabama that we're missing here? Like, why?
It wasn't my hesitation. I personally do not have a problem with it. While we were on scene, I don't think anybody realized that the tag was switched. And when we kind of went back and did a hot wash on it later, we all came to the conclusion that if we had determined that while we were on scene, then we would be
Okay.
perfectly okay with extending the stop. The only issue with the being a suspect involved in criminal activity in another jurisdiction that we had was it's not our jurisdiction. We don't know the ins and outs of the crime,
Mhm.
liability issues and certain things there coming from like a supervisory
I see. Now that
side
makes
of things.
now it makes more sense. This is not just a basic Fourth Amendment issue. This is something more, I see. It makes more sense now. But yeah, I mean, look, at the end of the day, though, you have reasonable suspicion that criminal activity is afoot. The fact that it's not in your jurisdiction, I mean, that's a different issue, right? You can still help build cases for crimes that happened out of your jurisdiction. I mean, hell, if you had a reasonable suspicion that he committed a crime in California, you could detain him.
Sure.
So yeah, I think we're good.
Sweet. Thank you.
Yeah, no, thank you, man. Awesome. Okay. Okay, so what? So look, I thought James' question was really good. I don't know if he wants to come on the mic. Maybe it's already answered, but James says, correct me if I'm wrong, states can be more restrictive than the federal standard, not less restrictive. That's your classic, New Mexico. That's your classic New Jersey, Montana. We just talked about Montana, right?
Yeah.
Montana, running a dog around a car is federally compliant. Like we can run a dog around a car, if it's an impound lot, if it's a parking lot, but then you got this, Montana thing going on. So that's a great example of that. All right. Look, let's do, actually, we answered let's answer another question here. So let's answer this one. Let's answer number 3. If anybody has a microphone, you can try to jump on here, but let's answer Nick's question from Scottsdale, Arizona. He said, can officers be the victims of disorderly conduct? You've heard this before, right, Zach? Like
I got it right in front of me. Yep.
you can't, well, you can't breach a cop's peace, right?
I've heard that. Yeah.
I recently taught a constitutional law class, and the materials I was provided, it stated that because of case law, officers cannot be victims of disorderly conduct. In my research, I was unable to find any case law that sets this precedent. Am I missing something, or can you shine some light on where this rule comes from and so forth? I think what's going on here is when they say disorderly conduct, they're talking about freedom of speech. They're talking about people yelling at the police and causing a disturbance. That's what I think they're talking about.
Yeah. Words alone cannot be disorderly conduct. They have to be fighting words. They have to be words that are exempt from First Amendment protection.
Yeah, I mean, so
yeah,
that's really what I think is going on here. Like, look, so the way that the public gets treated by somebody, look, I guess maybe this is a bad example, but you have like this person who may be unhoused or whatever is yelling, F you, you're evil, and I hope you die in hell, maybe, because that may not be freedom of speech necessarily, that might be, it's not fighting words, but I don't know. And maybe that can be disorderly conduct, but saying those same things to a police officer is going to be very hard to charge under the First Amendment. Because it may be political speech. You may be saying to your government that I hate you. I think that, I don't know, maybe it's a bad example, but the point is, I just don't, I think what they mean is this freedom of speech stuff. I don't know. Zach, do you have a different take on this?
Yeah, well, and to his first question, society is the victim of disorderly conduct. It's conduct that disrupts public order. It's not an individual person, but the person to whom it's directed, the conduct, I think I agree with what you're saying to a degree. Yeah. So if you're directing it towards a government official, there certainly are some broader First Amendment implications than towards just a private citizen. But
That's
society
exactly
is
right.
the victim of
Yes.
disorderly conduct.
Yes, and also I think there's a public policy here where a police officer's peace can't be disrupted. It's the policy that the courts do expect that police officers are able to handle a higher degree of criticism and stress and confrontation than the little old lady walking on the street with a guy in her face saying F you. You know what I'm saying? So
Yeah.
I think that's part of it, but I get it. There's not a particular case law that I can think of off the top of my head, but I think that's the concept that we're talking about.
Yeah, and Nicholas mentioned in the chat, it's Chaplinsky versus New Hampshire. That's the seminal Supreme Court case dealing with First Amendment and disorderly conduct type statutes. It's out of the 70s.
Yeah. Harassment may be a better fit. Harassment for the citizen or the police officer. Again, unless there's a case that just came out of Nevada about obstruction. Zach, on your neck of the woods on the East Coast, do cops abuse obstruction and use it for contempt of cop?
Not in Virginia because our obstruction statute is very narrow.
Right.
But in other places, yeah, hindering, obstructing, it's a big, yeah.
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 And
It's
so
just
what
kind of a
happens?
catch-all category for people
It's a
who are,
catch-all, and it's been
not
used
doing
for contempt of cop.
yeah.
So
exactly.
now the Nevada Supreme Court jumped in and said, hey, look, enough is enough. No more, because there was a lady, look, I get the cops' concerns, but the case is, I want to say Wilson, but that's probably not it. But the Nevada Supreme Court, the case was involving a lady in Reno, scratch that, Carson City, and she was yelling at cops, trying to engage a juvenile in the streets, holding a knife to his stomach. And he was suicidal. And for whatever reason, this lady, her name actually was Wilson. It was actually, the reason I hesitated was Willson. It's kind of weird spelling. But Wilson was yelling at the cops, and whatever, she was saying, she was basically like, they had to like put down the bean bag and they're like, hey, come on, can you stop talking? We're trying to deal with this. And eventually they got the kid, in civil custody, right? Civil commitment, but they hit her with obstruction for yelling all this stuff at the cops. And because she was hindering, right? Taking away your focus, as a lot of our brethren would like to say. And the Supreme Court of Nevada says no go. They're like, that's not obstruction, right? It is what it is. Yes, it slows you down. It does take away your focus, but it's not a physical obstruction, and it's not fighting words.
Yeah, that's how Virginia's is interpreted. It has to be some kind of physical act that hinders the officer's investigation.
Yep. All right, James, you got one question? Do you want, and I think it should be the same everywhere. I mean, look, I don't like the fact that these people act like psychopaths, but at the same time, I see a lot of abuse here. So we have to push back. I don't like people going to jail just because they disrespect their government. I disrespect my government. I have a lot of problems with how the federal government is running some stuff, but I don't want to be arrested for it if my views are, contempt of the feds. James, you want to ask one last question before we leave and we'll call it a day, or no? I can try to turn on your mic. What's up, Nick? Okay. James. Let's try it. I think James, you want to answer a question, right? Or ask a question? Hey, what's up, James?
Hey, I'm doing
Your last question of the night.
Awesome, thank you. So I'm going back to the search of the occupants, and I guess at the very end of the original show. So the way that we do it is, I'm in Mississippi. So if you have reasonable suspicion to believe that, reasonable suspicion, whatever. A canine comes, alerts on a vehicle, 8 alerts, and we allow a search of all of the passengers of the vehicle. So what do you think about that?
Wait, you're saying that, we talked about this. You're saying that, I know you're in Mississippi. What county in Mississippi, by the way?
Harrison.
Okay. So I teach a decent amount in Mississippi, and
Right.
you have a lot of great people. Have you been to one of my classes over there, or Zach's?
Yep. We've had lunch. It was years ago though.
Yeah, okay. By Bubba?
It was actually in Lafayette, I think in like
Lafayette. Okay.
2020.
Okay, look, so here's the deal.
Yeah.
Your dog alerts on the vehicle.
Right.
And are the passengers in the car or outside the car?
They're outside.
Okay. And so are we looking to just alert and then just start searching those people like right away type mentality?
Yeah, like I guess it would be search the vehicle, search the people.
Okay. So then you find nothing in the vehicle, right?
Right.
And then you start searching the passengers.
Right.
And
What
then
do
when
you
you go ahead.
What do you think about that?
And then when you go to court, let me ask you this. I'm your judge, okay? I'm gonna be your judge for a second. When you go to court and I ask you in open court, why did you search the passengers? And what are you gonna tell me?
Kind of put me on the spot a little bit, but
I mean, but I'm just, if you don't have anything, that's fine too, because that's
Well,
probably,
I
right?
mean, it would be along lines of, the dog alert to the presence of, say marijuana, right?
Well, you
And,
don't know what it alerted to. Do you smell marijuana?
no,
Okay,
obviously,
good. I like that because that's gonna help
yeah,
my fact pattern here.
right.
Go on.
Dog, that's why you call the dog, whatever.
Right, you don't
But
know if it could be cocaine. You don't know. Okay, go on.
sure, yeah. So the dog alerted to, like some sort of illegal narcotic that they're trained to alert to, right?
Mhm.
You search the vehicle, you don't find anything in the vehicle, and then you start searching the passengers, right?
Okay. Yep.
That at that point, I guess, if you're in court, you're finding you found something on one of
Correct.
the passengers, right?
Right.
Uh,
We're in court because we found something.
yeah,
And now you want to know if that's okay. Now let
yeah.
me ask you this. Let me ask you this, James, because I know we're running out of time, but I think I have your answer.
Yeah.
If you stopped a Greyhound bus for speeding, and while you're riding, you know where I'm going with this, and while you're writing the ticket to the driver, you ran the dog around the bus and it alerted, and you find
Right.
nothing in the Greyhound bus. Are you searching 35 passengers? Yes or no?
Yeah, that's definitely unreasonable.
But why is it reasonable then? Because there's 4 people in the car. In other words, I know it's different. I know it's different. I'm not stupid. I know that a Greyhound bus is fundamentally different, but why, from the court's perspective, where is that nexus? Where
Yeah,
is the
right.
abnormal nervousness? Where is the
Sure.
evasiveness? Where
Sure.
is the reactions not consistent with instance? Where's the
Yep.
whole, you're not going to find anything in that car. Where is
Right.
the lying? Where is the criminal history? Where,
Yeah.
and so the other example I use is the Greyhound bus is kind of extreme. And then I set you back. Now, what about the Uber? I mean, I don't know. I mean, maybe the Uber is not a bad, but I'm just saying, where is the articulation?
Right. And like I don't get out and beat the streets a whole lot anymore, but I supervise a bunch of young cops, and I want to be able to like point them in the right direction of the right way to do things, and that's just the way that we do it. And I'm always about articulate, but I guess at the very end when you were talking about searching occupants, you pointed out that the canine alerting doesn't give like a free for all to search everybody. You have
Definitely not. Definitely
to
not. And it's
yeah,
helpful. It's
articulate.
helpful. It's helpful. It's just not enough. It's not the only thing you need.
Right. And oftentimes like all the time, just about like 99% of the time, the officer who is calling the canine because they have reasonable suspicion to believe that a crime has occurred, is about to occur, or has already occurred, whatever.
Yep.
They are focusing on the driver,
Right.
they're focusing on the passengers, right?
Right.
So,
Right.
yeah, and a lot of times, I mean, the passengers are the ones that are found with something after the canine alert, and they search people according to the canine alert. So I guess what I need to do is I need to start harping on focusing on the behaviors of everybody, not just the driver.
Yes, absolutely. And look, I have a report writing class, and my report writing class is all about articulation. This is the missing piece. I'm telling you, your cops, you and your fellow peers are typically doing the right thing. You are searching passengers, and your intuition is getting to the right place. But when we
Right.
go to court and you're saying, Your Honor, all I have is a dog alert in the car, and hell, they're not even in the car, Your Honor, they're outside the car, and they're
Right.
passengers, and there's
Right.
nothing else. You should lose that case.
Yeah. So you putting it into words like makes more sense. You know what I mean? So yeah, so that's what I'm gonna start working on with my guys, is articulating not just the driver, but everybody else in the vehicle.
Yes. Now,
Right.
James, can I give you something before you leave? So
Yeah.
I have the report writing class is online. Can I give you
All right.
access to that just so you can? Hey,
Yeah, absolutely. Yeah. I mean, I think I'm in Biloxi, Mississippi,
oh,
and I
nice.
think that you recently came, or you or one of your people recently came to Biloxi, and like I mean, I've given my guys your like your books, you know, so that they, you know, they can like
That's awesome.
reference as a really good reference guides or whatever for me. But yeah, absolutely.
No, well, you had me at hello. Hey, Rick, do me a favor. Just email richard@bluetogold.com. He'll put you see the chat, it's right there.
Yes. Yeah.
And he will give you access to the on-demand version to the report writing class, and that will help you talk to your friends about this. There's an acronym in there. It's called NERDS. It's the best thing I can come up with because quite frankly, people like Zach and I are just nerds and we can't get away from it. It's nervousness, evasiveness, reactions, inconsistent instance, deception, specifics about them or the environment. These are the things we're looking for. That's the nexus. Those are the top 5 things, and so forth. James, you're awesome. I appreciate you, man. Thank you so much for coming on. Really think you added a lot to the show. Now beat it. So I want to be like funny, I'm trying to be like a shock jock. You know what I mean? So, but look, I love you guys. Thank you so much, Zach. Man, awesome. Anything else to say before we leave, my friend?
No, as always, had a good time. Glad to be here. Enjoy it.
I love it. All right, guys, thank you so much. That's all we have for you. Rick, do you have anything else you need to say before we go? And Blue to Gold mom, she's so proud of her sons. Mom, I told you, I just so you know, Zach, I told my mom that when I, got off parole, I was going to make something of myself. And this is what I've done.
And look what you've become. Yes.
Absolutely.
I'm sure mom's very proud.
Mom is very proud. I have not been in trouble in many, many years. Okay. What's up, Brad? All right, guys, thank you so much. We're going to end the show. It's 10 o'clock my time. It's 11 o'clock Zach's time. And we got to go. I got class tomorrow. In fact, we got a lot of things tomorrow. Thank you guys so much. I appreciate you. If you're watching on demand, please watch us live go to bluetogold.com and sign up for the next show. All right, my friends, stay safe.
Take care.